Now I would like to introduce today's presenters. Gene Quinn is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Robert Schaffer is an intellectual property partner at Troutman Sanders. Bob applies more than 30 years of experience to IP counseling and litigation. His work includes patent procurement, strategy planning, and transactional advice, due diligence investigations, district court patent cases, and Federal Circuit appeals. Also joining us is Thomas Franklin, partner at Kilpatrick Townsend, who focuses his practice on patent prosecution, licensing, and intellectual capital management, with more than 15 years of experience with intellectual property. Thanks again today for everyone joining the presentation, and with that, I will turn it over to you, Gene.
Thank you all for joining me in our panel here today for this conversation about 112, which has become a larger and larger part of patent practice over the last several years, is the hunt for the invention, as it is sometimes called when we are talking about 101, is at issue. But 112 really is the bedrock of everything. It pulls it all together, because if you don't have a description of the invention, then you don't have patent eligibility, and you obviously don't have something that can be described as novel and non-obvious. So we have in store for us a jam-packed conversation today on 112, and we're going to start with briefly with some trends. We're going to go through the case law from the Federal Circuit and the Supreme Court, and then we're going to also, throughout our presentation, talk about what that means to USPTO practice and what you can do to avoid 112 rejections with respect to all these new teachings that are coming out. Now, the one thing that we're not going to touch on today too much, although it will probably come up on some level, will be the drafting of patent applications. So rather than have a webinar that just really touches the surface of everything 112, we decided to split these into two. So we're going to focus on the law and how to react at the Patent Office to the law. And then later on in November, we already have scheduled, and we'll get to that, and we'll announce the date is already set, and the link where you can register is already up. Another webinar where we will go in the next step and say, now armed with all this information, what does this mean about how you should be drafting your applications? So we're going to take a holistic approach to 112. Enough talking for me. What I'd like to do is turn to our panelists and give them an opportunity to give their preliminary thoughts on 112 before we jump into the slides. Bob, let's turn to you first. I know you're going to be focusing on the case law for us, but I want to just throw it out to you in an open-ended way. Where do you think we are with 112, and what do you think people should be paying attention to?
Okay, so I want to back up slightly and talk about patent climate, because I've observed over the years that there's a continuing pendulum of pro-patent, anti-patent, and that swings back and forth somewhat. And when we head into a climate that, for whatever reason, is somewhat anti-patent, we start seeing rejections increase and cases being fought over either those rejections or grounds for invalidity in district court. And so there was a period back in the day when 101 was a big deal and everything was being rejected under 101. Then we had the heyday of 103, where everything was being rejected for obviousness. And while these things don't go away, and 103 certainly never goes away, when there is an inclination to be stricter about allowing patents or upholding patents, then people look around for what they can use, and what I think they're using now is 112 more than anything else. And they are using it to say pretty much what Gene said in the beginning, to say that we don't really know what your invention is, you didn't really tell us what your invention is, you didn't tell us how to practice your invention, so 112 is holding you to this high standard that you're not living up to, and that's what a lot of the cases are about. What actually is the Section 112 standard, whether it be indefiniteness or enablement or written description.
Okay. Well, thanks a lot, Bob. Tom, let's turn to you to get your perspective. And I know you're going to talk primarily about what goes on at the Patent Office, but I don't want to limit you to that. When you're thinking about 112, where do you think we are currently with the state of affairs today?
So I agree with Bob's impression that it is very popular now. It's a popular way. But there's always kind of been something that they throw at us. And the messaging is clear. I think the courts keep saying, write a better patent application. The funny thing is our clients keep saying, we'll do it cheaper. So I hear the old timers at the firm, you know, the guys that have been practicing 34 years, telling me about how the budgets that they were given 30 years ago are the same budgets we're given today, but billing rates have kept up with inflation. So what it means is that a lot of people are just kind of ripping through the drafting phase, doing it as inexpensively as possible, but yet the courts keep saying, whether it be under the rubric of 103 or 112 today or 101, they keep saying, you know, describe better what your invention is and how it's enabled and how it works. Yet seemingly the messaging from the clients are, but do it for, you know, far less money in a you know, an inflation-adjusted sense today. So
really true. I really agree with that, and I also want to add that claim drafting comes into play as well. They're also saying write a better claim.
Yeah, that's right. Absolutely. They're just saying generally do a better job, but you know, when you're in a hurry, because clients get it, but maybe they don't. They seem to think that something written for 30% less than perhaps the budget you want is going to be exactly the same, but really isn't. They're getting exactly what they're paying for, and you're rushing through the claims. You're not getting very creative in describing things. The detail around the heart of the invention, maybe you're skipping over it a little bit. And, you know, something is lost when you rush through. And what I'm doing now with clients at beauty contests, I'm like, look, here's 3 different price points that I'll do it at. At this price point, this really low price point, I don't know what you're going to get. I don't like to write them that way. Here's what I'm comfortable with. You can get an excellent case at this price point. And I let them decide a little bit and throw it back in their laps, because there's a lot of the competition is just trying to write these really slap-shot cases, which has tended to be a large part of my practice now, is just in-transfer fixes, is taking this stuff and trying to do something with it. And we'll talk about some of the dangers of that as we get through the presentation.
Yeah, I mean, I think this is a really good conversation, really interesting conversation, because I do think that at the end of the day, clients need to start to pay more attention to what the courts in the Patent Office are saying, which is the law is different. You cannot get the same protection, or any protection really for that matter, to be honest, with the kinds of budgets that they want. And if they want to continue to be in the patent game, I think increasingly smart clients might want to divert their budget that might have been spent in yesteryear for a C portfolio or a C patent and say, do we really want to even go after that one, and maybe divert those kind of resources to spend more money and more time getting the ones that really matter. But, you know, that's a conversation I think that obviously hasn't seeped all the way through the industry, and one we probably continue to have. But let's get through and start with the trends, and maybe that will make some more sense. Tom, I know you want to talk about some trends at the Patent Office, so take it away.
Yeah, so we all had a sense that there were more 112 rejections. That's what our gut tells us, you know, as we're interacting with the patent office. But Patent Advisor has tools now, so you don't even have to rely on your gut. So we went through and we looked back to the last 5 years. We probably should have gone 10 years into this because the data's kind of funky. There's almost a doubling between 2013 and 2016 in the number of cases that have 112 rejections. And I'm not sure if that was a temporary blip, but that certainly jives with what I see at the office, is that I don't know if they did training in 2013 or what they did, or I don't know what causes these trends, but it certainly is there. We almost have a doubling in the likelihood you're going to get a 112 rejection on your case. The other trend, I practice a lot. I do a lot of this in-transfer problem area stuff, so I end up with a lot of cases in business methods. So the thing that I had been seeing, and it's borne out true in the data, is a situation like this where you get a case, and we've all seen these cases. I liken them to napkins. Two biz dev people sat at the bar and wrote something on a napkin, and you filed that as a patent, right? So you have 3 screen scrapes and a flow chart, and maybe a generic computer block diagram is kind of your case. Well, today what we're seeing is 101 rejections on those. And we'll often go back into the case and think about the fact patterns that get you past Alice and the situations that get you past Alice, and try and creatively draw something out. So hopefully we can get an amendment that might get you patentable subject matter in the business method areas. And what happens next is you get a 112 rejection, as they say, well, it's not properly supported in there. And the Patent Office has a very narrow interpretation of 112. They almost want literal support, whereas I think the case law is broader in that it has one of ordinary skill in the art and so forth, and the knowledge that's common, but really the Patent Office wants to see it literally supported in there. So it's really common now, if you can beat the 101 with some amendment, they come back at you with the 112 and say, yeah, okay, maybe you're past 101, but you don't have support for what you're saying. And they really want you to go to literal support. So we've seen this trend, and you see an uptick around Alice, but it's been an ongoing trend that first office action 101 without a 112, subsequent office action brings in a 112. And I presume that's because somebody amended aggressively or creatively or didn't have exactly literal support, perhaps because it's one of these paper-thin napkin type specifications.
Okay. So this is just here to remind everybody that there are 2 versions of every statute now. In this case, old Section 112 and new Section 112, or post-AIA 112. The cases are still overwhelmingly dealing with old Section 112. Many of them have footnotes that say the law has changed and this is now 35 U.S.C. 112A or B, etc. And so they seem to be signaling that when the new Section 112 cases are before the courts, they're going to be pretty much handled the same way as old Section 112. And that's what I'm predicting. But everyone should be clear that there might be some room in the future for somebody to say that, well, new Section 112 requires something a little bit different. So there may be gamesmanship on that point in the future. But for now, we're still in the cases dealing with 112 as it was. Tom, I might just ask you to jump in and say whether you see anything going on in prosecution under new 112 that is different.
Yeah, so I mean, a lot of the subtlety that we see in the case law is just lost at the Patent Office. They seemingly will get a list of profanity, patent profanity words that you can't use. You know, wherein, they started attacking wherein or configured to. And you'll see this kind of come through in waves where, you know, all your office actions for a month and a half will attack some new verboten word. And because presumably somebody went through the patent office and trained on it. And it's really, you know, whether they're talking about new or old 112, it's typically a recent case that precipitates that training, but it's somewhat random. You just really never know, but it does come in waves.
Okay, so let's go to the cases. There have been two important Supreme Court cases on Section 112, and they both relate to indefiniteness. And this is a look back to 2014, kind of a 3-year. What's happened over the last 3 years. And one thing I think that's going on somewhat even beyond Section 112, but these cases are good examples, is the Supreme Court is telling the Federal Circuit, you guys are being too aggressive and taking it upon yourselves too often and too broadly to say what you think a patent is when the district court or the patent office has done a lot of work before you. And then the Federal Circuit has been spending a lot of time recently telling the patent office, you guys in the patent office are doing a much too superficial job in reviewing patent claims and deciding whether they're patentable. And that plays out in these Federal Circuit 112 cases. So there's this thing going on right now where each tribunal is kind of looking below and saying, we don't like what you're doing. We think you're a little sloppy. So the most, I think, at least for me, interesting one here was the Nautilus case, which overruled Federal Circuit standard of Section 112 indefiniteness, which they call the insolubly ambiguous test. So what that meant was that if terms in a claim were challenged, typically in a litigation, more so than in the patent office, but if they were challenged and any interpretation could be put onto those claims to save them from being hopelessly or insolubly ambiguous, then that was good enough to overcome at least Section 112, although you might get a claim construction that did you no good for infringement or validity. So the Federal Circuit for a long time was saying, we're going to assume these claims mean something and that the meaning is ascertainable, and you have a really high bar to show that there's just no way to interpret this claim language at all, and therefore it's indefinite. And the Supreme Court said, that's no good. It does not provide adequate notice of what claims cover, and that a precision more than not absolutely insolubly ambiguous was necessary. And then, you know, what that precision should be turns out to be case by case on the facts. The next Supreme Court case was, let's see, the Tether case. And that was a case that has been common more recently, where there is some parameter in the claim. A molecular weight in this case, it could be any number of things. where the claim is challenged by saying, well, yes, you have a range in the claim, but the artisan wouldn't know how to measure it and would get different results according to different measurement methods, and therefore the claim is indefinite. Here, the court said that you can, based on the facts, assign a meaning to the molecular weight, and then there were standard ways to determine molecular weight, and the specification in that case gave some examples, and it was improper for the court to simply de novo ignore the facts in order to come up with its own claim construction. So this case was interesting also because it not only dealt with 112 and somewhat a little bit contrary to Nautilus, said that you could find a claim construction even that was a good one, even though there was vagueness. So between these two cases, there's some sort of boundary of what is sufficient precision. This case shows that it doesn't have to be excruciating precision. It just has to be precision supported by substantial evidence in the record as found by the district court. And the Federal Circuit cannot decide it likes other facts better in the guise of a de novo claim construction. So that's what was going on there. And moving on, other indefiniteness cases.
I'd like to jump in
Go
here
ahead.
Really quick, and this is Gene, and I want to highlight something for everybody here, Patent Office related. It's come to light over the last week or so, and some of you may have known this longer, but it's something that the Patent Office, I think, has done a fairly good job at keeping a lid on. The Patent Office does not follow Nautilus. They have explicitly stated in a precedential opinion from the board just recently in Ex parte Mic Award that they do not find Nautilus to be binding on the Patent Office and are going to continue to ignore it as if it doesn't exist and follow old Patent Office law in Ray Packard. Now, don't want to get too far into that, but I want to bring that up since we're talking about the Nautilus case here, and it's something we've written about recently on IP Watchdog, and the Patent Office has filed a brief at the Federal Circuit. So this is going to be teed up at the Federal Circuit over the next, I suppose, 6 months or so for the Federal Circuit to decide whether or not that is a proper interpretation. But it is something to keep in mind whenever dealing with the Patent Office.
Do you consider that to be a Patent Office view of what broadest reasonable interpretation means? That they want to keep doing that?
That's what they're saying. They're saying because they apply the broadest reasonable interpretation, they don't. Nautilus is not binding on them, which to me doesn't make any sense. I don't understand how or why the verbiage of the Nautilus test can't be applied using the broadest reasonable interpretation. So they're not even using the same verbiage of the Nautilus test. They're using the verbiage that exists in the MPEP and the verbiage that it comes from in Ray Packard, which they come up with a number of reasons, including one is that, you know, Nautilus is litigation and the patent is already issued, and they say it's based on broadest reasonable interpretation, but I don't know that you need to have two legal standards. You could just have the same legal standard and have one that is implied using the Phillips, which is a more narrow interpretation, and the same test, the same verbiage using BRI. I don't see the need for an entirely different test. So this is really, I think, bizarre, but I just thought, since it's coming up, the Patent Office is finally taking a position on this over the last week or two in a couple filings. I think people probably do need to be aware of it.
And one final comment on Nautilus. It used to be really hard to make a Section 112 case because how many cases really were insolubly ambiguous. Now that that's gone, it's easier to make these challenges stick, and I think that's one of the reasons we have an uptick in Section 112 rejections and in Section 112 defenses in court.
And I imagine if they had actually adopted Nautilus at the office, we would see far, far more 112 rejections. Modicum of uncertainty really.
Well, that's interesting that you raise that, because it seems that the Patent Office believes at least in the filings and in the most recent presidential case, which has really just come out over the last couple days or so. You know, it was mailed to the parties back on August 25th, I think, but you know, it takes a while to percolate through the system, really, because there's not a great way to get your hands on these, even once they're made precedential. You know, it takes a while to come out and be noticed. But the Patent Office seems to be taking the position that the Nautilus standard is a more lenient standard, and that the standard that they apply is a more restrictive standard. Although when you read their interpretation, it's hard to parse it, admittedly.
Yeah, I think we all are at risk of being confused between claim construction issues and Section 112 issues. I mean, indefiniteness is somewhat of a claim construction issue, but it also is something that ties the claims to the specification. And so if you're more concerned about the claims, you might want broadest reasonable interpretation and not want to deal with Nautilus. If you're more concerned about, I need the patent to say what the invention is in clear terms in the specification, then you're in the Nautilus area.
Right, and I don't know that I personally have an answer right now. It's just adds further to the uncertainty that exists in the patent space, and I suppose the even greater need that when you're working on something of consequence, you really, really do have to try and convince the client to go the extra mile, to let you go as far as you need to go, because right at the moment there seems to be dueling standards between what may be applied in court and what may be applied to the Patent Office. And where that winds up, who knows?
Right. I'm going to skip over some of these cases now, and let's go to the deletion test. That's the Cox Communications case. That one was really interesting because what the court seemed to do was to decide whether a claim term made the claim as a whole indefinite. They pretended to take the term out of the claim. In this case, it was the term processing system, which was being offered as a means, not as a means plus function claim, but as something that was so open-ended nobody knew what it was. They took it out of the claim in a thought experiment, and then concluded that the steps of the method claim were still the same steps, and the scope of the claim really didn't change. This is not a preamble limitation, and therefore there was no indefiniteness. I don't know how this will really hold up. It was 2016, and it may be too early to see if people are applying a deletion test. But it's really interesting because I always thought it was one of the canons of claim construction that all terms of a claim have meaning, and terms of a claim can't be removed or ignored. Yet here the Federal Circuit said, let's pretend it's not there, and if it doesn't make any difference, the claim is non-indefinite. And actually, I'd be interested to hear what you other guys think about that.
Yeah, I agree that sounds a little crazy. You just don't pull something out of a claim, although what isn't a processing system? I think there was another way to look at it, is that it is a known element, but, you know, everything's a processing system. I am, for goodness sakes. I had bacon and eggs for breakfast, right? So I think there was probably a different way to decide that, but, you know, you shouldn't be deleting something from a claim. That's preposterous.
Yeah, I'd have to agree with Tom. I mean, there's got to be a better way to come up with that, because, you know, the problem with something like the deletion test is now there's something like that's out there, and whether or not that can be or should be the result to this particular case, we all know how those kinds of tests wind up being used by whether it be examiners or PTAB judges or district court judges who may have a philosophy that is not particularly patent friendly, you know, and if you can delete things for one purpose, why can't you delete things for other purposes? And this is a real criticism of the Federal Circuit that goes back since as long as I've been practicing, is, you know, there's precedent on practically every issue, if not every single issue. And it's frustrating.
So let's go on to written description. There's one case I wanted to talk about. That's the Script Pro. For everyone on the call, there are more slides than we have time to talk about, so you can look at these cases if they interest you.
Let me just jump in there, too. That was my decision, everyone. And we knew we weren't going to be able to get through all of these, but Bob had, and Bob, for those of you who isn't aware, him and his partner, Joe, they write the Federal Circuit Review, which they send out by email, and then we republish on IP Watchdog every week. And the summaries here are great. They do summaries every week of Federal Circuit cases. So we really wanted you to have all of this information as a reference. I found all these things very useful myself, and I thought you would as well. So we realized we weren't going to be able to get to all of them. But so go ahead, Bob. So
what was interesting in this case was that even though it was a written description case, what the court found was that the claim, which was for a collating unit to dispense prescription pills, required sensors, or at least the specification that the inventor did not have possession of any collating unit that did not include sensors. But sensors were not recited as an element of the claim. And so there was a dispute about whether an essential element had been left out of the claims, and therefore a claim without a sensor was supported or not supported by a description that only talked about sensors. And here the Federal Circuit decided that the inventor does not have to claim every feature that would be in a final working product. The inventor can claim the combination of features that he or she believes he or she invented for use in let's say, the collating unit. So these guys did not invent sensors, they weren't required to make the censors a feature of their claims. That I want to contrast with the Promega case, which comes up under enablement. There was a DNA forensic kit for analyzing short-term repeats, which are DNA segments that have what are known as loci. And here the claim was directed to a kit comprising 3 specified loci. And so there was an argument about whether the claim could encompass additional loci, like an unclaimed element, like a sensor from the other case. And here the court decided on the basis of the facts and the claim language that this was not a case where the claim was directed to unrecited elements. This was a claim that was directed to future inventions, namely other loci that would work in the forensic analysis invention when such loci were unknown. And the distinction may be that it would not have required undue experimentation to have sensors in the other case. Here, it would have required undue experimentation to have these additional loci. They're also a little bit reverse of each other because this case claimed another element through the open-ended language comprising, and the other case arguably left out an element. So that was just interesting to me, the way written description and enablement come out in different ways. So I think I should stop. There are a whole bunch of means plus function cases, which are interesting in their own right, but I think we need time to deal with the other issues and time for questions.
There's one that, Tom, I know you wanted to talk about, which is the Williamson's case, correct?
Yeah, that's right. And back to my earlier theme that sometimes it's these thinly drafted cases that are the ones where we're coming up with new law. The actual law here I'm going to ignore, but what we did is I took a few of these cases that looked particularly thin to me, and I ran them through Patent Optimizer, the Patent Optimizer tool. This one had lots of red flags. So I know that's very hard to read, but with Patent Optimizer, you can load your case as you're drafting it into the tool, and it will tell you whether your antecedent basis is correct. So here, you know, you should always have a check mark there for antecedent basis, and all those terms are claim terms, and where you don't see an X, they didn't have any antecedent basis for it. Which, you know, digressing for a moment, when I see a 112 issue, you know, rejection at the office, I say I didn't do my job right if I wrote that case. Because those are kind of rookie moves in my mind, is we shouldn't be making antecedent basis having antecedent basis issues. Sometimes there's these verboten words that go in and out of vogue. You know, about used to be fine to say something like that, but now they should be very definite. There's certain things like that, but, you know, antecedent basis is absolutely a rookie sort of mistake. Lacking support, yeah, you amended something in there that didn't have support. when I see a 112, I feel like I didn't do my job right. Well, in this particular case, when they look to see whether there was description, that second column is description. So in the first instance, Patent Optimizer goes and looks for the exact same wording in the specification. And it doesn't, you don't have to have one-to-one correspondence. It has a way to look at things that are generally alike too. But here, none of the nouns phrases were in the specification. And this specification was one of those really thin specifications. And then it also will look to see, it'll tell you what reference designator corresponds with that noun. So if you've used, classroom region in your figures or in your spec, it'll say, well, that has a reference designator of 36. So this case, in my opinion, could have been drafted better. And something like Patent Optimizer will force you down this thought process to double check everything. And and no tool is exactly perfect, but here's a case that had issues with 112, and really it was really thin, and a tool like this would have identified some of the issues.
And I think cases like that even get allowed.
Well, there you go. I mean, that's what 101 solves, is those napkins that are. If you throw enough napkins, I mean, colloquially, patent applications that are about as detailed as a napkin. If you throw enough napkins at the patent office, eventually something gets through, and that's a licensing program, right? Because it's very broad. So yeah, no, I totally agree. I mean, I just, as part of the patent bar, we should challenge ourselves not to do work like this. And if we get a client that wants us to write cases for whatever, $5,500, $4,000, I go through the math and I say, well, I had a plumber at my house this morning, and plumber's about $100 an hour. I should have asked him if he could have drafted patent applications, because that's what you're paying people, is $100 an hour to do this. And, if you're expecting anything better than what a plumber would do, you're just wrong generally. Maybe you found that one magical person that can somehow do an amazing job for plumber-like wages. But, we all went through technical school, have an advanced degree in law, many of us. Look, it's just not practical to price that level of expertise at the same thing that you would price somebody fixing your pipes.
Right.
Another way also to look at this case, apart from the actual law that they made, was if people are going to write specifications and claims this sloppy, we need a way to apply Section 112. And since everybody is being too sloppy to use the words means for under Section 6 the way they should, we need some leeway to decide that claim language that didn't use the magic words still falls under that means for statute, and that's kind of what they were dealing with here. So, the sloppy case ended up making a Federal Circuit pronouncement about what a means plus function claim is.
It's the old saying, bad case makes bad law.
Yeah.
Yeah, and I don't mean to particularly pick on this case. This is all too common to have really thin cases like this. We do a lot of this in-transfer fix-up stuff, and we got one case that was very much in this style, which, perhaps pre-Alice was okay to do. It had 14 rounds of argument. And that's another thing that no one takes into account is those cases that aren't drafted well for whatever reason tend to require far more argument. So I think the company that's pushing for really inexpensively written patents is actually paying more to get that patent in their portfolio. because often the difference is maybe the cost of one round of argument. But, you know, in this portfolio that we took, you know, 14 rounds was common, was the worst. 14 rounds was the worst, but 6 or 7 rounds was very, very common. And if they saved a couple $1,000s writing each case, I would say they were ripped off. So it's actually, you know, better to, in my opinion, draft a decent case following all the rules with the right length and detail, and then, you know, you can argue it much more effectively, and it is a lower cost to get that patent in the portfolio than this. Because in this one, you might as well add the litigation costs in there too, because you had to go to court to get it interpreted, which is a cost of writing it in a sense, right, that could have been solved by, you know, noting Gene's point, it could have been solved by better drafting.
Yeah, and, you know, not to excuse this, but I just pulled up the patent. The filing date here is September of 1998, and this patent was issued in December of 2000. So, you know, this is a legacy patent, and there was things going on back then that certainly the industry would not tolerate today, and the patent office would not tolerate today. I think if you file an application like this today, you've got 0% chance of getting something issued. So this can't be something that you model after. And this is, well, it's not as frustrating right now, but, you know, back 10 years ago, certainly 10 years ago, maybe even a little bit earlier than that, but certainly 10 years ago, you deal with clients and they say, you know, I've gotten these kinds of patents. Why are you telling me I need all this information? It's like, well, because things have changed, and they've only continued to change. And the amount of information that you need in these things is just ever greater and greater and greater. And, you know, having a tool like Patent Optimizer, I think it can be really, really helpful because, you know, these things, these patent applications like this are not short. You know, gone are the days for a very long time that an application dealing with any kind of computer-implemented technology is a short, brief application. I mean, these things have to be dense. They have to have a weight. You have to be able to weigh them. They have to look real. They have to be scary in terms of technology. I mean, they have to be disclosing something. There has to be something there. That's just the reality of it. And when you have those long disclosures, having a tool like this can save you from simple mistakes in a world that is cramming down the amount of money that you have to time to invest.
Yeah, I think that's a good point. These were all too common, these sorts of applications. And certainly 101, there's no chance something like this could survive a 101 challenge today.
Okay, so Tom, where do you want to take us here now? I think you have a few.
Yeah, so I'm going to do a little bit more background on Patent Optimizer.
Okay, well, let me throw this one question on here, and then we can go into there. I think it's quick. Do software and business methods tend to have significantly more 112 rejections than other tech areas? That comes from somebody on the call.
Yeah, so I mean, I'm seeing a lot more, but I practice mostly in that area. I would say the EE stuff, the electronic stuff, has less. But I was talking with one of my colleagues doing mechanical prosecution, and he says it's pervasive. So, you know, the trend, as I looked at the trend against all the tech centers, certainly it's up. There was kind of, I only found one little pocket of one tech center where that wasn't trending up on the 112 rejections. So I think everybody's getting more of these across the board, whether it's worse in business methods. I mean, business methods, there's that trend, that second graph that I showed, that there's, you know, this 101, you solve a 101 and you buy yourself a 112 problem. But no, all tech centers are seeing an uptick in 112 rejection.
Yeah, and that's what I see. And let's not forget that all of the emphasis on patent quality by the Patent Office over the last 3 to 4 years has really been about 112. It's been about telling the industry, give us better applications, and better applications with better disclosure is all about 112, whether it's paragraph 1 or A, or, you know, better claims under paragraph 2 or paragraph B, whether we're talking pre or post AIA. So it's not surprising to see it up across the board. What I've also heard from people who do a lot of software type stuff at the office is they get 112 rejections sometimes even when there is direct corresponding one-to-one support in the specification, and examiners will say, well, you only mentioned that once, so you haven't really made a very big deal about it. And you know, that's just hard to wrap your head around, how an examiner can reject you when they're admitting that there is support in the spec. But in some of these art units, they don't want just support. They want real support, not just sort of casual, oh, it's there, see, let me point you to it. They want more than just throwaway support.
Yeah, and I think, you know, good patent drafting, you get down to the heart of the invention, and then you can't write enough about that. And I tell associates I'm training, you know, not 2 sentences, a page. If you could write 100 pages, I'd go back to the client and say we need more budget. That's what a good patent is all about. When you go and the examiner's found art that nails you on what you thought was your point of novelty, and you go back to the spec and there's 2 sentences, and your heart sinks. But if you go back there and there's 6 pages on it and different ways to look at it, you're like, oh my gosh, I know we can get a patent.
And we have a comment here from somebody saying that he has just gotten hit with a 101 in a hard EE interface case, and it's crazy. There is a lot of craziness going on, you know, at the patent office right now, and so you have to impress upon your clients that there is this craziness out there. And if they're giving you unrealistic budgets and you're willing to work with them, that's one thing, but I think you've got to be honest with them about what that's going to mean. That's got to be the takeaway, I think. And
I think one of the things is kind of my soapbox. I in-person interview all my cases if I can, or WebEx if I can. But I am out at the main patent office 1 or 2 weeks a month to do that, because a lot of the wackiness, right, like a 112 on a hardware, or 101 on a hardware case, or Gene's example where they wanted you to talk about it more. I mean, I just asked the examiner, you don't like consisting of, or you don't like some terminology like about or sort of, or whatever it is, you get something weird, pick up the phone and ask the examiner, because often they don't know and you just end up arguing against yourself. What I find is typically they've gotten training, and it's almost like this word is verboten, here's the word that we're using today. And you sit there and decide if that works for you. And you can dispose of these issues very, very quickly, especially on the 112 side, where a phone call ought to be able to solve most issues. Pick up that phone, you know, drive over to the office, talk to your examiner, because often you're going to do more to fix it than the examiner actually wanted.
Okay, Tom, you have a couple more slides you want, or at least one more slide on Patent Optimizer you wanted to say, and then I think we're going to need to wrap up here. We're getting towards that hour.
Yep, so here's just a little bit on the interface for Patent Optimizer. I have kind of the screen where you can turn on and off different things to look at. You know, like any computer program, it sometimes gives you funny answers. It's like talking to a robot. There's a little bit of tweaking you have to do and deciding what is helpful for you or not. What I find is a lot of this stuff, I had to kind of mentally have this system in my head to write a good patent application as I trained myself over the years to write good patent applications. This one last slide that I'll show you, it can go and create a parts list and enforce that parts list on you as you write a case. It can do that either for as you're writing it, or you can put a PDF in there and it'll, like on the example on the left, it takes all those reference designators, goes to the spec and tells you what it's called. So it makes it easy when you're analyzing a patent. They have a similar tool, and I've given the interface there, where they can analyze a patent and look at different things when you're trying to come up with 112 arguments as a litigator. So these are fairly mechanical things. When a computer can figure out how to do it well, you know, it's pretty mechanical, pretty routine. So to the extent that you need help or you want to double check, absolutely, there's Patent Optimizer and other tools out there that can make sure that you dot your I's and cross your T's.
You know, and I like what you said. It forces this upon you, which I think is really, you know, important. And over the years, people have heard me talk about drafting and so forth. I always think there's not nearly enough figures in most patent applications because, you know, figures are worth 1,000 words, if not more. And for every figure you have in the application, you're going to force yourself to draft at least 1 to 2 paragraphs talking about that figure. And you're going to talk about not only what's in the figure, but a lot of other things that the figure what comes to mind, what's being shown in that figure. Then you layer on a tool like this that forces you even more to make sure that what you're saying is actually in unison with what you're claiming. And I mean, it just, you know, there's the reality out there is not a nice reality for patent attorneys. We're getting pushed to do more and more with less and less. And the courts don't really care that we're getting pushed to do more and more with less and less. These 112 cases are coming up, and now we have a duality of standards between the patent office bickering. They don't want to follow Nautilus, and where's that going to mean? What's that all going to happen? And the push for quality is not going to end. And all along the way, they don't seem to really care about examiner quality all that much. It's always our quality. So we have to keep trying to figure out ways to deliver. So if this is useful to you, give it a test drive. Tom, if you could flip to the next slide, I'd appreciate it. We're going to talk about how you actually manage in this world to draft, given the realities and trends, in order to avoid problems. On November 9th at 2 o'clock, the registration page is already up. You can go there today right after the conclusion of the webinar to register. We hope you'll join us for that part 2. In the last few minutes that we have remaining, what I'd like to do is flip it back to the panelists, though, to wrap us up here for today. Bob, what is the takeaway message that you'd like everybody to leave with today? And then, Tom, I'll ask you the same question.
One big takeaway. There really isn't one. It depends whether you're in the patent office or in court, but let's say you're in the patent office. I think the biggest takeaway for me is that drafters need to spend more time, matching up their claims to the specification. There were a few cases in here that we didn't talk about. One of them was that it's okay to use synonyms sometimes. But as the Wilkinson review showed, you can get into a lot of trouble with that. So I think that something that sometimes gets overlooked in the rush that we've been talking about is we write a patent application very fast. We need to get it on file. We have first to file now. The budgets are low, and so we might even put in a provisional without claims, or we write claims really fast. And somehow I've seen a lot of cases that have come to me for cleanup in the way that Tom was talking about, where somehow the right claims never got drafted. Or at least I've been litigating cases where that happened on patents written, you know, before I was even doing this work. So that would be my big takeaway. Make sure the claims match the spec. And if you can't make them match, then you need more work on your spec.
Okay, thanks, Bob. Your final.
I would just say, you know, I want to challenge the patent bar. You know, when you get a bad haircut, you walk out of there saying, I got a bad haircut. Often our clients can't judge quality because it's hard to dig in and see if you really hammered the point of novelty and if you wrote enough on it. So I would just challenge everybody to find a way to do amazing work, to really hit on these issues. And if you have a client that is not going to give a budget to write something up properly, at some point you just ethically have to say, I can't do it, really. I can't do a great job on that. or you eat it, you know, as a loss leader or something like that. But at the end of the day, you know, it's an embarrassment when you get a 112 rejection. I mean, you should feel personally embarrassed, unless it was one of those verboten words that you couldn't have anticipated when you wrote it. So I challenge everybody, you know, kind of as a matter of ethics, is we should all be pushing toward avoiding these issues, because there's a wave coming. Both Bob and Gene talked about it. 112 is the darling of the courts and the patent office now. It's in the statistics. So don't get crushed by that wave. Really challenge yourself to connect everything very, very well and really have a lot of detail when it comes to that point of novelty.
Okay, and I think that's a great message. Don't get crushed by the wave. And I appreciate you all for joining us. Thank you, panelists. Thank you, Bob. Thank you, Tom. Thank you, Reed and Lexis. And we look forward to hopefully having you join us on November 9th for the part 2 of this Trends, Realities, and Avoiding Rejections webinar. You all have a good day and a good weekend, and enjoy the start of the NFL season tonight. Take care, everyone.